Creamer Media's Polity, I'm Sashnee Moodley. Researcher and analyst Professor Raymond Suttner joins me for Suttner's View, a weekly commentary on South Africa's political scene. Hi, Professor.
Hi.
We have only recently had the Constitutional Court hear the Nkandla case, which is likely to result in findings that are embarrassing to Zuma, Parliament and others. And now the DA has initiated a case to reinstate charges against Zuma. How do you understand these developments?
Yes, I mean, in the first place, we're spending millions of rands in legal fees for a lot of things. In some cases, they have denied certain material at one level. Then when it gets to the Supreme Court of Appeal or the Constitutional Court, they admit all these things. So that all that money spent in denying it has been wasted. And this is going to continue, I think, because I don't think the second case, the DA case, will be over, whatever the decision is now. The way I see it is the Constitutional Court case has been very damaging already to President Zuma, because everything that has been denied for years with regard to Nkandla has now been admitted by his counsel. And you can already see that people are saying, well, really, we didn't support, we did feel he should pay the public protector. And a lot of people are very embarrassed because they've had to, because of the rules of caucus of the ANC, you just vote. And whether you believe it's wrong or unconstitutional or contrary to your oath of office, they have felt that they should do this. We can debate whether that is an issue of principle, because some people would say that to abide by the discipline of the caucus is an issue of principle, whereas some people would say to refuse to carry out an order that is illegal is an issue of principle. That is the principle of the Nuremberg trials. I'm not comparing these. In the Nuremberg trials, they found that if you're given an illegal order, you have a duty to refuse to carry it out. So it's compromised a lot of people. And the EFF, who brought this case, although the DA joined in, others became friends of the court, the EFF is obviously hoping that the way in which the Constitutional Court will decide in the Nkandla case will be sufficiently broad to help them with a motion for the impeachment of President Zuma. Personally, I don't think the court is likely to do such a thing. I think that the court will be very reluctant to make findings that go beyond specifically legal matters. In other words, the fact that the president may have failed to abide by his oath of office, may have failed to comply with legal provisions in regard to the public protector, are not issues that they raise ethical issues, and they raise issues about the compliance of the president with his obligations as president. Now, the court is not really obliged to make a statement on that, and they would be very reluctant to make a statement which then becomes a political football in Parliament. So I think we can expect the findings to be limited. The second case has been going on for a long time. The DA applied for access to the spy tapes. You'll recall that in 2009, Zuma was facing hundreds of charges of corruption, racketeering, fraud, and so forth. And on the eve of the court case, Mokotedi Mche, the acting head of the National Prosecuting Authority, withdrew the charges. And he withdrew these charges on the basis of tapes which the NIA had obtained. Somehow they landed in the hands of the Zuma defense team. And it appeared from these tapes that Bulelani Ngcuka, former head of the Scorpions, and Leonard McCarthy, who was in the prosecuting team, had been having conversations about when Zuma should be charged, because they felt that if he were charged just before Polokwane, it would seem like it was an attempt to interfere with these presidential chances and all those things that were not really, strictly speaking, prosecutorial matters. They were political matters. And Mche said, hearing these tapes, he offended his sense of justice, and he felt that he couldn't continue with the prosecution on this basis. Now, there were other people in the prosecution team, like Wim Trengove and Billy Downer, and they didn't agree with this decision, because what they argued, and this is argued in the DA case, is that the interference of McCarthy and Ngcuka affected the timing of the prosecution. The actual charges against Zuma were not tampered with at all. So the integrity as charges under which he should have been prosecuted at one or other time was unaffected. And Mche referred to a case in the House of Lords, and in fact that case says that if there is an irregularity of this type, it must be left to the court to decide if it has any effect. And there's a decision in the Supreme Court of Appeal. Judge Harms also said a similar thing. So that Mche's reference to the House of Lords doesn't bear him out. Anyway, Zuma's charges were withdrawn. And for some years, the DA tried to get the tapes, and MPA wouldn't give the tapes. Although when it got to the Supreme Court of Appeal, they admitted that they had no legal basis to refuse to give them. So in fact, all the legal expenses for senior counsel, all of that, for years, had been wasted, taxpayers' money. Now, had I been the DA, I would have gone to court without the spy tapes, because you could actually argue the case on the basis of the reasons that had been given, irrespective of what was in the spy tapes. Because if it's correct to say that the integrity of the case as such was not affected, well, then the reasons for there was no justification for withdrawing the charges. So it may now in the case as being heard now by the full bench of the North Gauteng Provincial Division, the judges, the arguments seem to be to the effect that no matter whether this is a prosecution that ought to be held, we must protect the integrity of the prosecution process. You can't condone the type of interference that occurred. I mean, that's correct. I also condemn the interference, but that doesn't mean that the charges disappear. So it's not clear what they will find, but it's quite possible that they will make a finding. I think it's not correct, and I think this has come clear in the arguments, they won't reinstate the charges, because I don't think the court can do that. But what they could do is refer it back to the National Prosecuting Authority and say to them, we would like you to review the case and apply your mind to the question of implementing it or not. But in the meantime, even before that happens, it is likely that either side, whoever loses, will appeal to the Supreme Court of Appeal. And then whoever loses there will go to the Constitutional Court. Now, by the time all of this is over, by the way, if they're going to make a decision that the National Prosecuting Authority must make a decision, we've seen that the National Prosecuting Authority seems to be highly partisan, charging this chap Poison with the same indictment that's been thrown out before. It seems to be playing political things. But if it goes to all these courts, that means Zuma may well be out of office by then. And the balance of forces against Zuma being prosecuted may have changed by then. Paradoxically, the delay may not help Zuma, and they could well end up prosecuting him if it's delayed and delayed and delayed. So let's see. So that's the way I see it. I think it's very complicated.
And what is going to happen now?
Well, I think what's going to happen now is that more of our taxpayers' money is going to be spent, whether this is won or this is lost. And in the long run, as I say, it could well be that Zuma does get prosecuted. Personally, I think it was wrong to withdraw it legally, but it may be the court doesn't want to come to that decision. Either way, there will be an appeal. But I think the longer it goes, the more chance it may be that Zuma will be charged.
Thanks, Raymond.
Thank you.
That was Professor Raymond Suttner speaking to Cream Media's Polity about Zuma and the courts.